Well, thank you very much, Elma. Actually, I've changed the name of the presentation because I've changed my mind in the time from when we put in the submission. So it's actually the corporation as an entity, as you'll see up there. And actually, I feel like quite fortunate in the sense that, in that it relates so closely to the sorts of things we were talking about this morning. So I was actually, for once, itching to get up here and talk about what my ideas are about how we understand the corporation. Because I think one of the important points that was made this morning is that how we conceptualise the law affects how we regulate, but most particularly when we're studying corporate law, how we conceptualise the company affects how we regulate the company. And I think going back to first principles, that first question in corporate law, what is a company, in a way is also the last question. Once we figure out what the company really is, and you have to think there has to be some form of objective truth there. And once we figure that out, then perhaps we from there can move on to think about the kind of the consequences of that. But before I get underway, I did particularly want to thank Axel and Jean for inviting me. I should be the most grateful because I've come the furthest, coming from Auckland in New Zealand, but I also, please forgive me because I am quite jet lagged, so to me it's sort of 2 o'clock in the morning, so if I run off track or lose my place, you will understand why. So the corporation is an entity, so my argument is really to try and put forward a new model or idea of what the company is. And in the time that I have, I'll spend the first part of it telling you what I think that model is, and if I have time in the second half, talk about why I think the company developed in the way it did, and perhaps also an explanation as to why we don't currently particularly think about the company as an entity, at least in the way that I'm going to present it. So the first diagram there, now I actually googled nexus of contracts, and this picture comes up on the internet. And if you look at that closely, that diagram, I think most of you say, well, hang on, that's actually a picture of a stakeholder corporation. So actually what I learned is that sometimes the internet gets it wrong, and well, who knew? So, so actually, even though it says, well, it came up as next, it's actually a kind of pretty typical diagram of the stakeholder model, which of course is one of the dominant models of the corporation. And I'll go back to this diagram a little bit later in the talk, but you'll see there's a couple of weird things about it. The fact that it puts owners on the left as internal stakeholders, and then also puts shareholders on the right. So that's kind of interesting, isn't it? But apart from that, it's probably, if we're asked to draw a model of a stakeholder corporation, we draw something a little bit like that. And the other kind of big question, which is the thing I'll focus on, is it kind of doesn't answer the question it sets out to answer. Because it says, you know, if we're asking the question, what is a company? Well, of course, they put the company in the middle, so it doesn't answer, well, what is that company? And that's, I guess, what the focus of my talk will be today. Now, the other model, of course, that dominates, we're all familiar with, is the shareholder primacy model. So there's a diagram of that simple model, which of course forms the basis in many ways of agency theory. So the kind of rather simple idea, the company viewed from the perspective of shareholders, where the shareholders are the principal, the directors are their agents. The agency problem is primarily narrowing, if you like, the gap between the shareholders and the directors. So here we have two models of the corporation. And the thing about them is they're just so dichotomous, so different. So really it's quite amazing, isn't it, that they're so different. How can we reconcile them? Is there any way that we can explain the company both using the stakeholder model and some form of shareholder primacy model, or some way that takes it into account? It would seem to be impossible. And actually, to complicate matters too, there's also other models. So most particularly, everyone here will be familiar with the work of Stephen Bainbridge and his ideas about director primacy, which essentially isn't that different from shareholder primacy, except he puts, if you like, the directors at the centre or at the forefront. So sort of turns things around. But his fundamental understanding of the company is pretty similar to shareholder primacy people. And this idea, this contractual idea, that essentially a company is a nexus of contracts, that all the relationships are primarily contractual, and that if we didn't have regulation, well, you could get there anyway by using contracts. Now, one aspect of shareholder primacy which doesn't receive too much attention is where you put what I'm going to call the corporate fund. So essentially we know that legally and also for accounting purposes, the corporate fund is separate. So it's separate from shareholders. Salomon teaches us that. Corporate fund is separate from shareholders. From accounting, since we've had double entry bookkeeping, the fund has been separate, at least for accounting purposes. So then if you were drawing your diagram of shareholder primacy, where would you put that corporate fund? So one idea is, of course, that you would put it attached to the shareholders and inside that circle of the shareholders, which you might consider is essentially the company. Or if you follow Salomon, you think, well, hang on, it actually belongs there, outside, because actually the company is separate from the shareholders. And if the fund is the company, then it must be separate from the shareholders. And essentially that's the core of my argument, that in fact, at least since the later part of the 19th century and at least in Anglo-American, Australian, New Zealand jurisdictions, common law jurisdictions really, you have had, this is essentially what the company became. And the core argument, as which I'll show if I have time, is that there's something that wasn't the case when the incorporation statutes were passed, the general incorporation statutes were passed in the middle of the 19th century. But it's something that developed as a consequence of limited liability, as a consequence of the capital maintenance rules, and as a consequence of the case law moving in a certain direction, I guess epitomised by Salomon. So I think that's one of the reasons why we have these different conceptions of the company. That the modern company, if we think of the modern company being a company incorporated under a general incorporation statute, it actually changed once we had limited liability and through the 19th century. So if I'm right, then essentially that might be how you could draw the company. That essentially the company is a fund, at its core anyway, and that fund is a separate legal entity from all the different constituencies of the company, including the shareholders, and essentially consists of nothing else than essentially what was that joint stock fund. So if you were drawing a picture of a company on incorporation, it could look something like that. And you see the board there, this idea that the board is the mediating hierarchy, or in the director primacy idea that the board is of primary importance. Well, because if I'm right and the company is just a fund, it has to operate in the world. And who is its guardian and representative? Well, that would need to be the board. Now I'm going to try and defend all this in the second part, but I'm presenting the idea. Now the other part, which my very limited PowerPoint skills I couldn't really do, is that this is really a drawing of the company on incorporation. So on incorporation, if you think of the company as just a fund, well, it's really, at the moment of incorporation, it's just a right. And it's really the right to claim that initial capital from shareholders. And that's at the very essence of what a company is. But a company, unlike other firms, does have that core. But then, of course, if the company operates in the outside world, of course, that capital fund will grow, hopefully. But also, because the fund is a separate legal person, it'll acquire reputation, it will acquire goodwill, it'll acquire a lot of more ephemeral characteristics that aren't actually capital, but essentially would sit around the outside of the core that is the capital fund. So now I've presented the idea and you're thinking, oh, maybe Jean made a mistake bringing her over because this is a bit too wacky. Well, now I want to try and defend why I think this is essentially what a company is. And I guess there's two threads, and I think that there are two threads or two components that went into forming the modern company. And the two threads, first, that a company is a legal person, and we've recognised them as being legal persons essentially, actually since Sutton's case in 1612. But since this separation of the corporate fund or the entity from the shareholders, it's not a human being, and it doesn't contain human beings either. And importantly, really, I suppose, when you think about justifications for regulation, it derives its legal personality from the state and not from human beings. So the company is essentially, we used to have concessions for incorporation, well now essentially we have that you follow a process and a statute for incorporation, but in essence that becoming a legal person is still something that's conferred upon you by the state, but in a different way. So that's one aspect of the company which I'll try and show came from corporations law. And then the other important aspect of the company is this idea of a joint stock fund. and that joint stock fund came through another path, and both combined in the modern company. And then if you had this modern company, if you thought of it as the shareholders holding the joint stock fund in a legal person, then it separated in the second part of the 19th century, and that was a consequence of several aspects. Limited liability, creating that pressure to protect the corporate fund, strong form entity, petitioning all those reasons why the corporate fund needed to be protected. Took a while, and I haven't got time to talk about this, took a while to happen for a range of reasons. But you had legal, there was a historical form which people will be familiar with after the Bubble Act that had developed through private law, where you had a fund, so there was some kind of legal precedent where you had legal separation of the fund in a trust in the unincorporated form, but it took until the end of the 19th century for the benefits to be fully realised. So that's essentially the first part of the story in summary, and now I'll try and defend it, at least historically, which is all probably that I have time to do today. So I see the origins. When you go back, you can go back actually to Roman times, and some people argue there was there were forms of corporation universitas at that time. But in terms of what we should focus on here, which is probably the idea of a separate legal entity, well, some people think that developed with Innocent IV, who was a pope who had previously been a lawyer and had ideas of about arguably that the universitas was a separate legal entity. But really, there's no question, at least in terms of the common law, that what was called by Maitland the Italian theory of the corporation came into the common law in Sutton's case with Lord Coke, and the case and the report of that case in 1612. And even though that he might have appeared to adopt the idea or the Italian theory of the company or the universitas or corporation as a separate legal entity, it was really Coke who developed it. And I think, and this is where I need to do more work, I'm pretty sure that's where the common law diverged from the civil law in terms of corporations, this idea that you could have a separate legal entity that could exist, an idea, or just exist without perhaps even having a corporeal or earthly or physical form. And the reasons for that were, again, perhaps the particular facts of Sutton's case. And I don't know if any of you have read Ozymandias, the poem by Shelley, I Am Ozymandias, about, well, actually, Sutton is really almost completely forgotten, except for the name of the case and what it did to corporations law. But when you look at about Sutton, he was actually called Rich Sutton. He was perhaps the richest man of the Elizabethan era, so incredibly powerful and influential. And he had friends in high places. And in those less precious times, they didn't have conflict of interest laws or rules, so he was actually good friends with Lord Coke, who of course was eventually the judge in Sutton's case. And Sutton sought to leave some of his vast fortune to set up a Charterhouse School charity in London, but at the time the corporation was set up, the land hadn't been purchased. So when Sutton died, Sutton's heirs, who already were getting plenty, well, they wanted to stop some of the money going, or wanted to draw back the money that had gone in to purchase the Charterhouse Hospital. So that's what really Sutton's case was about. It was the heirs versus, I guess, the representatives of the Charterhouse School. And the problem that Lord Coke had, he knew ahead his, I guess, we would say, he knew, if you like, if you're not a cynic, that the outcome of, if the outcome was to be the outcome that was sought, then he had a problem that at the time the corporation was formed, the land hadn't been transferred into it. So essentially, the corporation didn't attach to anything in the way that corporations always had in the past. So the kind of basis of Sutton's case, the idea that the corporation was, if you like, could exist an idea, was just an entity and it didn't have to attach to anything, you could say was Lord Coke's way of getting around the problem, that the land hadn't transferred into the corporation at the time that it was formed. And from there, perhaps, arguably, we have our common law idea of separate legal entity. So that's one thread, and of course this is rushed. Now the other thread, the origins of the joint stock fund, which is the other component, important component in the modern company. Well, joint stock was an Italian, came out of the Italian invention or recognition of double entry bookkeeping. And once you could separate the capital fund from the holders of that fund, then that was kind of made all sorts of ventures possible, which previously hadn't been possible. And the fund was separate for accounting purposes. That's what double entry bookkeeping did. But it wasn't separate for legal purposes until the private law form of the unincorporated company, where the assets were settled on trust, developed after the Bubble Act in 1720. So what you had is a kind of legal precedent. A lot of people talk about, well, you can create companies by contract because look how successful the private law form was in the 18th century when we had the Bubble Act. But, and that's sort of true, except there were some problems with the contractual form because it didn't have the other aspect that's key, in that it wasn't a corporation and therefore not a legal person, not a separate legal entity. So then what you had at the time of the general incorporation statutes is you had that combination. You had the shareholders as a whole who held the corporate fund, that joint stock fund, and because it was a form of corporation, or at least the joint stock companies at that time were considered to be a form of corporation, it was a legal person and therefore a separate legal entity. And that became gradually more clear as the first part of the second half of the 19th century progressed. So that was essentially, I think, what probably Robert Lowe and the people who drafted the Companies Act, the General Incorporation statutes in the mid-19th century thought. If they had to draw what a modern company looked like, they would have drawn it like that. So it combined the corporation with the joint stock fund, and that was the joint stock company. It was the joint stock company that Adam Smith wrote about, except Adam Smith's joint stock company didn't have limited liability. But then what happened through the later part of the 19th century was that separation of the joint stock fund to have what I think is the modern form of the company. You had this, what you could call entity primacy, or what should be seen as entity primacy after Salomon. The separation of the fund, which of course gathers all sorts of things to it as a legal person, like reputation, separated from the shareholders and represented by its guardian, the board, that interacts with third parties on behalf of the company. So in terms of our theme for this conference, and thinking about, well, if this idea is right, what are the sort of issues that are created for corporate law? Well, all sorts of ideas about the problems of having nominee directors acting for shareholders, which essentially are parents. All the issues around that can be looked at a different way. And I guess primarily, though, the primary question, the primary issue for corporate law becomes, well, who has control of that entity, that corporate fund?